offices. I myself manage the offices in Morden and Winkler. We have the biggest labor and employment group in Manitoba. We represent clients in all sectors. And on a personal level, I've practiced labor and employment from the very start of my career, so for 12 years now. And I've practiced exclusively labor and employment until 2018 when I moved to Morden and Winkler, which is where I grew up, to manage the TDS offices there. And so I've developed a corporate commercial practice as a result. Now, just to give everyone a bit of a, I'll skip through here. This is me in happier days, pre-pandemic. So, you know, my hair is nicely done. I haven't been in isolation with 3 kids under the age of 4. I look very much different right now, far more frazzled and way less rested. But just to give everyone a bit of a state of the union before we jump into everything, I think as of this morning for the COVID pandemic, we were still sitting at about 281 total infections. I think by and large, the most of those have recovered. We're sitting static at about 6 deaths, which is fantastic that we've kept it relatively low. Although we continue to be in a state of emergency. And as of yesterday, we started re-engaging in the opening of the economy, or the province's first phase of that. We continue to be subject to tickets for businesses and individuals if we violate public health orders. And there are a number of travel restrictions that continue to be in place, including self-isolation when you cross borders and restricted travel above the 53rd parallel. I think it is fair to say, and you'll probably hear me say this a couple of times, is that we are in uncharted territory, both as a province and as employers. And so that's effectively what I want to touch on today, which is what do I need to know as an employer to navigate this pandemic? And so I'm going to focus on 2 things, sort of some of the issues or the common issues that you might see as an employer and as you're managing employees. And secondly, what are some of the new programs and legislation that have been changed or rolled out in response to COVID? I expect you've probably heard a lot about them over the past number of weeks. And so I won't go into great detail on those, but I will highlight them just in case there's something new in there for you. Now, in terms of issues that I've seen as a labor and employment lawyer throughout this pandemic, they can kind of be grouped into terminations, layoffs, workplace safety and health issues, human rights issues, whether or not you're an essential service, and what I'm calling the reboarding of employees. And I can't take credit for actually having made that term, but that's what everyone seems to be using. But it's a fancy word for recalling employees back to work. And so what I want to touch on with you guys today are the first 3 of these, so terminations, layoffs, and workplace safety and health, because not only have those been issues up to this point, I anticipate that they're going to continue to be issues. And from there, I'll touch on the reboarding of employees now that we're in phase 1 of the reopening of the economy, and touch on a couple of issues that I foresee in that regard. Now, from there, I'll pivot and we'll talk about something maybe a little bit more optimistic, which are all the programs and legislation changes that have been rolled out, and then we'll have a question period at the end. Now, I apologize in advance because when I do presentations, I actually prefer to be interrupted. I love it when people ask me questions because I'd far more prefer to have a discussion with you rather than just talk at you for an hour. And so while everyone's on mute, I still would encourage you to raise your questions in the chat, and then I can be interrupted that way, because as I said, I'm far happier to just enter into a discussion with everyone than just speak for an hour. So before I launch into the issues, what I'd like to do is kind of give you Scott's Employment Law 101 to give everyone a basic understanding of the legal aspects of the employment relationship. This won't be everything, but it'll be a couple of key points that I want to effectively lay a foundation so you understand when I get to the issues, why they're issues. And so hopefully everyone will bear with me because I will get to the point about why these things are important right now, but I just want to lay this foundation first. So in terms of foundational pieces, I think it's important that everyone understands that every employment relationship is governed by a contract. Now, that contract can be a clear written agreement, so you've actually documented something, everybody's signed on it, or it can be an oral agreement. So it's a handshake agreement. You're going to come work for me, great, we're shaking hands and we're carrying on. Each employment agreement, whether it's written or oral, will have both expressed and implied terms. So an express term is one where the parties have specifically talked about it. You know, my wage rate is going to be $15 an hour. I'm going to have 4 weeks of vacation, more specific items. In addition to the things you've specifically talked about, you're also going to have implied terms. And so those are terms that maybe the parties haven't necessarily agreed upon or talked about ahead of time, but they're part of the employment relationship nonetheless. And those can come from a variety of places. It can be a practice that's developed between the employer and the employee. It can be implied by the Employment Standards Code, which is our legislation in Manitoba that imports a number of basic rights and obligations into every employment contract, or it can be implied by the common law. Now, what's the common law? Well, the common law are a number of rules and laws that have developed over time, of decades and decades of judges having rendered decisions on court cases. And so to figure out what the law is, or the common law is, you have to read those decisions. And so a lot of the time you'll have both employers and employees not necessarily knowing what the common law is as it relates to employment matters, because very fairly, they haven't read all of these decisions. And so the key point that you need to take from this is that every employment relationship is governed by a contract, and that might include terms and conditions you're not necessarily aware of. The second foundational piece, and this is my Star Wars reference here for you guys, because yesterday was May the 4th. The second foundational piece I want to touch on is terminations, and to just give you a sense of some of the issues that arise in terminations before I go into why it's important in the context of COVID. So with terminations, I think there's 3 basic points every employer should know. The first is when you are terminating an individual, you can do it in one of 2 ways. So the first is the one people often think of, which is a termination for cause. So somebody has done something terribly wrong. They have stolen from the employer. They have not showed up for a month. They've punched you in the face as the employer. These are all terrible things, and they're things that fundamentally destroy the trust relationship between the employer and the employee. So that's the first way you can terminate. They've done something really wrong. The second way is when you terminate them without cause. And so you're not relying on a specific thing that they've done. You're not saying the trust relationship has been totally destroyed. It might be that they're just not a good fit. Or it might be, for example, in the COVID environment, you're out of work. There's no reason to keep them around anymore. Now, if you terminate someone without cause, then your obligation as the employer is to provide them with reasonable notice of that termination, or wages in lieu of that reasonable notice. Now, reasonable notice is its own animal, and it's derived from a number of different sources. You can look at the employment contract if you have one written out that deals with that specifically. You can look at the Employment Standards Code, which has basically a chart that says after X number of years, you get Y number of service. But there's also the common law that's a source of notice. And under the common law, what the courts or the judges have done is say, look, we're going to look at the entire circumstances of the employee. We'll look at their age, how long they've been employed, how much money they're making, how likely it is that they're going to find new employment. And we're going to come up with an idea of what reasonable notice is. So there's no set chart. It's more of an art than a science in terms of figuring out what that notice is. But the reality is that notice under the common law is often far more excessive than what entitlement is under the code. Just to give you an example, there's a bit of an unofficial rule that notice under the common law can't exceed 2 years. So you might have scenarios where an employee is entitled to up to 2 years of notice or wages in lieu of notice, which is incredibly significant if you've got the wrong or right employee, depending on how you're looking at it. The third thing I want to highlight with respect to terminations is another common law concept, and that's called constructive dismissal. Now, constructive dismissal is a doctrine that says if an employer makes unilateral, fundamental, negative changes to the employment relationship, so the employer is changing something on their own to the negative, so it's not like they're giving you a raise, they're, for example, maybe taking money away or reducing your hours, you may have constructively dismissed your employee. If you have constructively dismissed your employee, then that employee is entitled to wages in lieu of notice. And so you need to be aware that there are scenarios where you can unintentionally terminate your employee when you're making changes to their terms and conditions of employment. And I think that's important in today's COVID reality because, again, reduction in hours, reduction in pay can result in constructive dismissal. In fact, a layoff can result in a constructive dismissal. And so these are things I'm going to come back to. But those are the fundamental pieces that I kind of want to touch on before I jump into why there are problems with respect to COVID. So why are these things issues right now? Well, in terms of terminations, it's important right now because if you're terminating an employee without cause, so you're not saying they did something terribly wrong, it might just be because of a lack of work, which I think is a very real possibility for a large number of employers these days, you're going to owe that employee notice of their termination, whether it's working notice or wages in lieu of notice. So it can create severance obligations for the employer that are very significant. And it might not be just what's under the Employment Standards Code, it might be what's under the common law as well, which can be significant. So in terms of terminating employees, the key point to remember is before you terminate anyone, just call your counsel and address the scenario with them, see what the risk is, figure out if there's a way to navigate it, and understand what the risk is so you're comfortable taking it on before you make that decision. The second reason these things, or with terminations, are important in the context of COVID is because if you're unilaterally making changes to the terms and conditions of employment, you're reducing their hours, you're putting them on layoff, you can constructively dismiss them, again, triggering these severance obligations. So if you are intending on making changes to the employment relationship, you're reducing pay, reducing hours, layoffs, you're going to want to talk to your counsel again ahead of time to sort out whether or not there is truly a risk in those scenarios and whether it's one you're willing to take on and whether or not you can navigate that risk. Now, this was only a very general explanation of those particular issues. There's often far more to it. And so take this as merely trying to flag the issue for you. So if you're entering into any kind of consideration about these issues, it can twig in the back of your head and you can go, oh geez, I remember Scott talking about this. Perhaps we need to call him. Perhaps we need to call our own counsel to work through this ahead of time. So the next COVID-related issue that I want to talk about a little more specifically are layoffs. And layoffs are something I have seen very frequently with my own clients because when this pandemic hit, it hit fast, it hit hard, and the impact of all of these things was very quick, and everybody was scrambling to try and deal with the new reality that work was effectively drying up faster than we could react to it. So when it comes to layoffs, I think there's two specific issues that people need to be aware of, and one of them I've touched on already, which is the notion that under the common law, a layoff may constitute a constructive dismissal, unless it's an express or an implied term of the employment contract. And so just to go on a bit of a tangent, that's why you won't really see this ever being an issue if you're working or managing a unionized environment, because in a unionized environment, you're going to have a collective agreement that's going to have a whole framework dealing with layoffs and seniority. And so it's an express part of their employment relationship. And so if you guys are operating in a union environment right now, you can kind of ignore this stage of the conversation. But if you're in a non-unionized environment, you'll want to pay attention. Because at the end of the day, if you want to lay someone off, it might result in an employee saying they've been constructively dismissed. Now, I'm sure there's some of you out there saying right now, well, wait a second, isn't everybody doing layoffs right now, or if you've even gone so far as to look through the code's regulations going, well, doesn't the code allow us to do this? The answer to both of those questions is yes. People are doing it, and the code's regulations do contemplate layoffs. But that doesn't mean that the layoffs aren't being undertaken without some risk. And it's often a risk that neither party, being the employer or the employee, is really aware of, because a lot of people aren't aware that under the common law, it says that you can't lay employees off without risking a constructive dismissal. And so we have the common law saying don't do it, and we have the employment standards code and its regs saying, yeah, you can do this. And so there's a conflict between the two. But the reality is that an employee could say they've been constructively dismissed. Now, even if an employee was aware of that, I think it's fair to say that it might not be that practical for an employee to actually say they've been constructively dismissed. And the reason for that being, if someone wants to say that they've been constructively dismissed, as an employee, their obligation is to immediately quit work, hire a lawyer, send a demand letter asking for wages in lieu of notice. And so to do that in the current work environment where everyone's hopeful that these layoffs are temporary, where if they quit their job, it's not exactly like there's a roaring economy out there for people to go find new work, and they won't have money to find a lawyer or to go pay for a lawyer. And so the practical risk of anyone actually saying they've been constructively dismissed is likely somewhat low, certainly far lower than what it was 2 months ago. But it's a legal risk nonetheless. And so at a minimum, just be aware that implementing layoffs could result in someone saying they've been constructively dismissed, although the likelihood might be relatively low. The second issue for layoffs that you ought to be aware of is the notion, or it's something called a deemed termination. So if you've been through the Employment Standards Code regulations, you'll see firstly that it allows for layoffs, but you'll also see this provision that says if you lay off an employee for longer than 8 weeks in a 16-week period, that layoff will then be deemed to be a termination. So it can turn into a termination if the layoff extends for too long of a time. Now, this was a huge problem at the start of this pandemic because everybody's looking at implementing layoffs. They have no idea how long this thing is going to take, and they're not sure when they're going to be able to recall people back. And they're looking at this provision going, well, our layoffs very well be 8 weeks, and we don't want to have our entire workforce terminated as a result of this thing. We don't call them back in time. Now, thankfully, the province has put in a temporary amendment to that provision. They've effectively said that where we continue to be in a state of emergency, that the deadline won't apply. So the clock right now, as of this moment, isn't running. But what everyone needs to be aware of is once the state of emergency is lifted, this clock will then start to run. So you don't want your layoffs to extend longer than an 8-week period once the clock is running. And so while layoffs originally, or what I'll just say is that layoffs may feel like they're relatively simple and straightforward, there still are some pitfalls out there for you guys to be aware of. There's a number of inherent risks that you don't always realize are there. So just keep them in the back of your head. Feel free to contact your counsel or myself if you want to talk your way through some of these problems. I think the other reality that we're seeing with a lot of these things is that things are changing by the day. There have been scenarios where I gave advice on Monday and it was out of date by Tuesday. That's particularly so if you are dealing with a workforce that extends beyond just Manitoba. So if you have workers in Saskatchewan, Alberta, BC, every scenario is going to be a little bit different. Every province has been making different changes to their own employment standards legislation. And so just be aware that every province needs to be dealt with specifically.
Scott, we do have one question here.
Sure.
Sorry to interrupt, but it's just from Ron saying 8 weeks from the end of state of employment or security of employment, SOE.
Yeah, so the way the timeline will work is that the amendment says effective March 1st, the clock stops. And so from March 1st till whenever the state of emergency is lifted, there's no clock. And so if you've laid them off during that window, the clock will start once the state of emergency is lifted. If you laid them off before March 1st, presumably that time will count up to March 1st, and then the clock will restart once the state of emergency is lifted. Did that answer the question? Thumbs up? Perfect. Okay, so the next issue are those related to workplace safety and health. So very generally in Manitoba, we have the Workplace Safety and Health Act that imposes a general obligation on employers to provide a safe and healthy workplace and to take steps so far as reasonably practicable to provide that safe and healthy workplace. So that's just a fancy way of saying is make the workplace safe for the workers. But what does that mean in the context of COVID? Because I certainly think that COVID would fall under the scope of the Act. Well, it's difficult to say for certain because everything is changing so quickly, both in terms of knowledge of the virus, how to respond to the virus, how it reacts. But at bare minimum, I think it would require identifying whether any hazards are present in your workplace for COVID, preparing a safe work plan for employees, and then implementing protectionary measures for that safe work plan and to mitigate the hazards. If you look at Safe Work Manitoba's website, they publish a number of steps you can take. Also with the government's, let's see what the document is called here, their phase 1 announcement of reopening the economy, they've got a page on employees that has a number of steps that you can take. So I'd encourage you all to review those for some ideas. But things you're going to be looking at doing is curtailing non-essential work. So having people work from home where they can, imposing restrictions to who can attend work, implementing social distancing, having creating education, cleaning, hand washing abilities, removing certain maybe I don't know what the right word for this, high touch objects. So something that's highly trafficked, highly used, stapler, for example, you might want to talk about maybe having more of those or dealing with those, removing them from the workplace if you can. And so you've got this overarching obligation to create a safe and healthy workplace. But what's perhaps been less discussed, and I think we might start seeing a little bit more of this, particularly with reboarding employees, is the right to refuse work and how that's going to play out in your COVID reality. So under the Workplace Safety and Health Act, a worker can refuse work where they believe on reasonable grounds that the work constitutes a danger to their safety or that of someone else. Now, the province of Manitoba has said that work is dangerous if it's a hazard that's unusual to normal working conditions, it's likely to result in a serious injury or illness, and reasonable controls are not put in place. And so realistically, in my view, I think COVID would fall under the scope of this, or at least arguably present an unsafe workplace. And so it's up to the employer then to put in reasonable controls to mitigate that danger, so that if the employee ultimately does refuse, you can argue that they're not refusing the work on reasonable grounds because you've created all of these safety measures. It's not actually an unsafe workplace anymore. And so in trying to determine if your workplace is a dangerous one, I think you should look at a number of things. The number of employees you have, whether someone's been exposed to the virus, are you in a workplace with an increased risk, such as a healthcare environment, or one where you've got close interaction, maybe your massage or your physiotherapies who are working closely with clients. How likely is it that your employees will be exposed? What kind of control measures are implemented? There's a number of things you can look at. Now, ultimately, there are no guarantees. You can take all of these steps and you still might get complaints because you ultimately can't control who complains. But what you can control is what steps you've taken to mitigate that risk, getting your ducks in a row in advance so you minimize those complaints ideally. And if they do occur, you're reducing your own exposure in your own defense. So the fourth COVID issue that I want to touch on before I jump into the programs and changes to legislation are those related to reboarding employees. So calling everyone back to work. Now, we are largely in a great social experiment right now. As I said before, we're in uncharted territory. And the next stage of that uncharted territory is reopening the economy, bringing everyone back to work. Now, I think that this is going to lead to a number of additional issues, more than what I'm talking about here today. But I think these first two are ones that you're probably going to see most frequently and probably first. And so the first is those folks who are refusing a recall, saying they want to stay at home, they're not comfortable coming into work. And the second are bringing someone back on different terms and conditions of employment. So in terms of those folks who are refusing a recall, in my mind, this is an intersection of workplace safety and health law, the new Employment Standards Code amendments, which I'll come to. They're actually on my next slide. And just a general duty to comply with an employer's instructions. And so what I think you're likely to see here are employees who are issued their recall notice, say, we've got work for you, we're ready to bring you back, but they're saying we don't want to come back. They might say that they're feeling unsafe in the workplace. They might say that they've got continuing obligations at home, like I've got kids at home who can't go back to school yet and someone has to take care of them. Or they might come up with something totally different, the unstated reason being they want to stay at home because there's these shiny new CURB programs that are giving them $2,000 a month to do nothing. And so they're coming up with a reason to stay home because they want money for free. Now, each scenario will have to be dealt with a little differently, but I think at a bare minimum, when you have someone indicating to you that they don't want to come back to work, the first thing you should be doing is pinning them down to a reason that they don't want to come back to work. I think you're going to see, at least with, I call them the frequent flyer employees, but everyone's got a particular employee who's always got a problem about everything. They complain about this, they complain about that. They game the system in any way they can. This is going to be no different. People are going to be trying to game the system. And so with these folks, the best thing you can do is pin them down to a reason for not wanting to come back to work. Because if you don't pin them down to a reason and you respond on the basis of what you think they're asking, they're going to shift and say, well, that wasn't the real reason I wasn't coming back. It's this other thing. And then they're going to shift again, and they're going to shift again. And they're going to say just enough of the right things to make it problematic for you. And so you want to pin them down, because what that does for you then is it gives you a concrete basis to respond to them. So if you pin them down and they say, yeah, it's because I'm feeling unsafe, well, then you can deal with it from that perspective. Well, we've gone through the workplace, we've implemented all of these safety procedures. This is not an unsafe workplace. We don't agree with you. You need to come back to work. Or they might come up with something else. But it's important to get that specific reason so that you know what you're responding to. The second thing you're going to need to do is when you get that reason, you got to be prepared to be flexible. Because we're in such uncharted territory, there are going to be situations you didn't see coming. There are going to be things that are borderline, and there are going to be things that are positions taken that are in good faith. It's not always going to be the good or the frequent flyers who are gaming the system. There might be some very difficult scenarios raised by someone in good faith. And so you need to be prepared to be flexible, to consider each circumstance for someone who's refusing on its own merits and in light of their own circumstances. So you don't want to give a blanket yes or a blanket no. If someone's refusing, you want to consider their circumstances individually. So if they're saying they, oh, sure.
Sorry, this is a hot topic, so I have two questions here, if you don't mind.
Yep.
The first one is, if we want to merge two positions into one and restructure the job description, offer the higher paid employee the new position at the lower wage and reduced benefits, could this be considered constructive dismissal?
It could be, but you're going to hear my favorite lawyer answer, which is it depends. And so you'd want to look at a bunch of different things, like how great is the change in wages? Like, are we talking about a 25% reduction? Are we talking 50% reduction? It's very circumstance dependent. And so I'll give you probably the most frustrating thing you're going to hear is it'll depend. And if you want to talk about it with me later, I'm happy to do that. but I would certainly say it's a possibility.
All right, and then our next question is a little bit on what you were just talking about. If someone refuses a recall and it is a unionized workplace, do I then follow the collective agreement or the labor standards?
The answer is going to be both to that one. So in terms of recall itself, presumably the collective agreement will have a provision in it dealing with recall and what happens when someone doesn't come back to work. But you still have to look at the reasons. So regardless of whether you're in a non-unionized or unionized environment, if someone is refusing, you still have to look at the reason. So for example, and this kind of dovetails where I was going with anyways, is when you're looking at their circumstances, let's say that they're refusing on the basis that, you know what, I've got 2 young kids at home who can't go back to school and someone needs to care for them. Well, under the Employment Standards Code, we have some brand new provisions that grant public health emergency leave in a number of circumstances, which includes staying home to take care of your children. And so if they have a legitimate leave or legitimately qualify for a leave under the Employment Standards Code, that takes precedence over the collective agreement because it's a minimum right that gets imported into the collective agreement. So those folks might be granted a leave of absence and legitimately can't be recalled. And so when I'm talking about being flexible, these are all of the things you need to consider. You know, are they, is it a safety and health issue? Have we dealt with that safety and health issue? Are they asking effectively for a leave that they're entitled to under the Employment Standards Code or under the employer's own policies or even under your collective agreement? If they're entitled to some of these leaves, well, then maybe the recall isn't appropriate. But if they don't qualify for any of those things, if there isn't a reasonable basis for not wanting to return to work, if they're legitimately just wanting to stay home to collect curb, well, that's not a fair reason. And so in those circumstances, you might consider discipline for disobeying a direct order from the employer to return to work, or even consider whether or not they're resigning from their employment. So there are a number of ways you can take it. And so that's why you need to be flexible. But remember at the end of the day that you do have options, and I'm here or your own counsel is here to help walk you through those scenarios. Now, so that was all refusal of recall. The next issue I think you're going to see is changes in terms and conditions of employment. So this is touching on one of the questions that was just asked. Because I think the reality is that very few businesses are going to be calling people back at full speed. I think you're probably going to call back parts of your workforce, or you might be calling back people at half time, or reduced wages, or combining duties. So all of those things were combined into that question. If this is triggering alarm bells for you guys, which it seems to have done, that's good. That means you were listening to what I was saying before. Because again, if you're unilaterally changing terms and conditions of employment, the risk certainly is a constructive dismissal. And so there's approaches you can take to navigate that recall. But the other part of it is I still think it's going to be very difficult for employees to say they've been constructively dismissed in these scenarios for a couple of reasons. The first is because you could say, like when someone says they've been constructively dismissed, they still have an obligation to mitigate their losses. They can't just sit at home, say they've been constructively dismissed, and wait for the employer to pay them. They have to go out and find a new job. And so if they're refusing reasonable employment, even with the same employer, they may be found to have not discharged their duty to mitigate, and so they might not be entitled to anything. And so the employee is going to have to weigh whether or not it's reasonable for them to be refusing whatever work they're being recalled at, because they might not be mitigating their losses. I also think it's going to be a bit of a bad look for those employees, because if we're in a pandemic reality where everybody is losing their jobs, where the economy isn't roaring, I think it would be a hard sell to a judge to say, no, I wasn't willing to accept 25% less pay or some additional duties that I didn't before. I just have a hard time believing a judge would be terribly sympathetic to an employee in those scenarios. Now, again, everything is always circumstantial. very dependent on the circumstances. But the reality is, I think constructive dismissal might just be a bit harder position for employees to take. So employers might be able to get away with a little bit more than otherwise they normally would. But be that as it may, the legal risk still exists. It's just that the practical risk may not be there in this environment. But again, everything is always dependent upon the circumstances when it comes to law. If you've ever heard me speak before, you'll get tired of me saying it depends, but that's the truth of the matter. No two situations are alike. So just to summarize then, if I can wrap this up with a bit of a bow, if you're terminating someone without cause, it's going to carry notice or severance obligations, possibly beyond that which owed under the code. It can be very significant under the common law. If you're unilaterally changing terms and conditions of employment, whether on layoff or in reducing work or on bringing employees back, that could trigger a constructive dismissal. Layoffs themselves could result in a constructive dismissal or at some point in the future, a deemed termination. Workplace safety and health matters are very much alive and well in the current pandemic. And finally, reboarding is likely to bring its own issues as well with respect to both the return to work and the terms and conditions that you're bringing the employees back on. Now, as much as being a lawyer sucks at times because it feels like you're a rain cloud. You're always telling people what they can't do and why this doesn't work in the circumstances. So just remember, even though I've raised all of these things, there are ways to navigate these issues, but you need to spend time working them out with counsel or the appropriate professionals beforehand, because it's far easier and cheaper to navigate them at the outset before the decision is made rather than after the fact. And I know that everyone is hurting, people are losing business, money for lawyers, isn't high on anyone's priority list right now. But it's truly a case of an ounce of prevention is worth a pound of cure. It is far cheaper to deal with it at the outset. And so with all of those issues, what I'd like to do is switch gears a little bit and touch on some of the new programs and changes to legislation that have been rolled out. And I say I've got about 20 minutes left, so I'll try and cut myself off after about 10 minutes, whether or not I've finished, to leave some time for questions if you guys have them. So in terms of legislative changes in Manitoba, I'm grouping them as two changes, but the first we have is with respect to the employment standards regulations. This is the one I've talked about already. So while there's currently a state of emergency, the 8-week layoff deemed termination clock is not running. It will start to run again once the state of emergency has lifted. So just keep this in the back of your head if you've got employees on layoff, that at some point this clock is going to start running again. The second is under the Employment Standards Code, and I've touched on this a little bit too, but there's two amendments that kind of work together. The first is that after March 1st, 2020, an employer may not request and an employer is not required to provide a medical certificate for certain leaves of absence that they may be requesting. That includes critical illness. It actually includes maternity leave, compassionate care leave, organ donation, critical illness, serious injury or illness, and the new public health emergency leaves. The rationale for this is that the government wanted to alleviate the pressure on healthcare providers so they're not spending all of their time providing medical notes, and so that they're actually giving patient care during the pandemic. So just something to be aware of. What I find very interesting about this is it's not just that an employee isn't required to provide, but it's that the employer actually can't request it. And so just keep that in mind, that if you're wanting to ask for medical information, if it's relating to any of these leaves, you can't do it, which is a very unique scenario. The second and related amendment is section 59.12 sub 2, and that's the creation of an unpaid public health emergency leave. So effectively, it's where someone is unable to work as a result of COVID. They are entitled to a leave of absence from work. And so this applies in scenarios where the employee is under investigation or they're required to self-isolate. the employer may have sent the employee home because they're worried that the employee has been exposed to COVID. They might be at home providing care support to an ill family member or caring for their own children who might not be able to go to daycare or who might not be able to attend school, which I think will be the one you guys are going to see the most. It applies for employees who have been directly affected by travel restrictions or they're acting in accordance with the public health order. Now, notably, these leaves don't have a set amount of time. They last for as long as the specific circumstances require. And so this is going to be particularly an issue to stay aware of in the onboarding or reboarding scenarios, because I think you're going to run into a number of employees who are saying, I can't come back to work for some of these reasons. So just keep in mind that these employees are entitled to leaves of absence and cannot be fired or disciplined if they're qualifying for these leaves. So from there, I want to touch on the stimulus programs that have been rolled out by the feds. And I'll preface it with Mr. Trudeau has been very big on announcing these programs, but less big on providing the details. And so they've been slowly filtering out over time. Now that most of them are now kind of up and running, we do have a far better sense of what the general requirements are. But we're also starting to see some of the problems that have resulted when you rush out programs. And that, to be frank, isn't a criticism at all. I think if any government was to put out quick programs in response to a pandemic, there are always going to be issues that result. And I think the one I was reading about yesterday is there was a number of homeless people in Winnipeg who were qualified for, had applied for CERB and been approved, and so they're now getting $2,000 a month, some of which was being put to good use, like new tents and sleeping bags, but a large portion of it was being used for drugs. And so there are some downsides to these programs as much as there are upsides to them as well. So I'm going to be focusing on the employment-related ones, but just to be aware that there are other programs out there for businesses. So make sure that you're looking at the Government of Canada's website to see if there's anything out there that you can take advantage of beyond just what I'm raising with you today. So the first topic I want to talk about, or the first program that's been changed, is the employment insurance program. So what the government has done with EI is to reduce and waive the waiting period in certain circumstances, the thought being we need to get money out to people as fast as possible. Benefits have been extended to people who are not just sick, which was normally the case, but people in quarantine as well, and the requirement for a medical note has been waived. The other thing to keep in mind for EI is that if you're applying for it after March 15th, you're not even going to be accepted into EI, you're going to be punted straight to CERB, so the employment or the emergency response benefit. The rationale there being they want to unburden EI as much as possible and allow people to get money faster, which is what CERB has been designed to do and seems to be accomplishing. The second program I want to highlight for everyone is the amendments to the workshop program. So this is a program that has existed for a while. It applies to year-round businesses. So it wouldn't apply to casual employees, wouldn't apply to seasonal businesses or employees. It also doesn't apply to people who are shareholders holding more than 40% of the shares in their business. But where you have a business that has experienced a 10 to 60% reduction in work, and you have a group of employees who have agreed to share the existing work that's left, you can qualify for this workshare program. And so what will happen is EI will pay benefits that corresponds to the amount of work that's been reduced. So if you've reduced 60% of your hours, EI will kick in corresponding amount. So in terms of changes, however, what the government has done is they've extended the length of time that you can participate in this program. So previously, the workshop program used to extend for 38 weeks. It's now been extended to 76 weeks. So you can be doing this thing for well over a year. The government's also waived the mandatory cooling off period. So previously, if you were in the program and you ran it through its course, you had to wait a certain amount of time before reapplying. That's been waived. So if you run through your 76 weeks and you need to go right back into it, you can. The recovery plan, there used to be a requirement that you had to provide a recovery plan. That requirement's been reduced to a single line of text, so the application process has gotten significantly easier, and it's now available for businesses who have been in operation for 1 year rather than 2. The next program is actually 2 programs, so it's the wage subsidy programs. There's the temporary wage subsidy program, and there's the Canada Emergency Wage Subsidy Program. The temporary wage subsidy program was the first one announced by the feds when the pandemic hit. It's retroactive to March 18th to June 19th, so it's running for 3 months effectively. And it applies to individuals, partnerships, nonprofits, charities, corps that otherwise qualify for a small business deduction. And a definite advantage to this program is that there's no application process per se. So what the employer does is they reduce their own tax remittances to the government by the amount of the subsidy. So effectively, you are subsidized by way of just not having to pay certain amounts of your taxes. The other thing to keep in mind is that you don't reduce the amount of CPP or EI that you pay in, but just the tax itself. The second program is CEWS, or the Canada Emergency Wage Subsidy Program. This one is far more lucrative is the wrong word, but it's a far bigger benefit for everybody. The details on this one did take a length of time to filter out, but it's up and running now. It's retroactive to March 15th. Right now it's intended to run to June 6th. And if you apply for this program and you're successful, the feds will subsidize up to 75% of an employee's wages for their first just under $59,000 of their salary. So if you have an employee making over the threshold of $58,700, the subsidy won't apply to anything above that threshold, but it'll still apply to 75% of that $58,000. This wage subsidy program extends to nonprofits and businesses of all sizes, whereas originally I don't believe it did apply to nonprofits or large employers, but now it applies to everyone other than a public body who is experiencing a 30% decline in business owing to COVID. It's also recently been changed so that if you can show a 15% decline in the month of March, you might qualify then. And when you're assessing whether or not you've experienced the appropriate level of decline, there are effectively 2 comparison periods you can look at. You can look at the same month in question for 2019, so you can compare March 2020 to March 2019, or you can take your average revenue from January and February. So if you don't qualify one way, certainly run the numbers the second way and see if you qualify that way. There are 2 cautions that I want to raise with this particular program. The first is that the government has said that the employers are supposed to use best efforts to top up wages to 100%. It is by no means clear to me or anyone else that I've spoken with what best efforts is. So presumably that means that if someone is taking advantage of this program, you're going to get into some kind of trouble, but it's not at all clear what that is or what constitutes best efforts. The second part about it is that the feds are going to introduce anti-abuse rules for this program. Last I checked, they hadn't yet, but they had set out what they think the penalties will be, which is repayment of any amount that you shouldn't have received up to 225% of that amount, so a significant penalty, and potentially up to 5 years in jail. So just be aware that this is a program that should not be abused because you are likely to get in trouble for it. The third program then is the Canada Emergency Response Benefit. This is one that's gotten, with CEWS, is probably the one that gets the most press. The intention certainly is to get money out to people as fast as possible. Notably for this particular program is that it applies much broader than EI would. So it applies to both employees and self-employed individuals, so folks who might not necessarily have been making EI contributions. But if you've earned up to $5,000 in 2019, you're at least 15 years old, you've ceased work for COVID-related reasons, so you may have lost your job, layoff, sick, quarantine, caring for a sick individual at home, or you're caring for kids at home who can't go to daycare or school, and you haven't been paid for 14 days in a 4-week period, you should qualify for this benefit. And that will pay you up to $2,000 a month, so 500 bucks a week. And it starts retroactive March 15th and will extend to October 3rd. When I last checked in, the applications were being processed and payments received within 3 days. I don't know if they've improved on that time yet, but that still is relatively timely. The other thing to be aware about it is that medical certificates aren't required. So if you're saying you're on sick leave, the government isn't going to ask you for a medical note right away. And you can't choose whether you're applying for EI or CERB. If you're applying for EI after March 15th, you're automatically punted into CERB. The other two things that I want to point out with this benefit or this program is that it doesn't apply to people who voluntarily quit. So if you're leaving work voluntarily and hoping to apply for this, it should not apply to you. You should not be getting money under this policy. The second and kind of related portion to that is, and you guys may have experienced this as well, but I've certainly have clients who have experienced this, but they've had employees approach them asking to be laid off, knowing that this program exists, even though work still exists with the employer. So what they're doing is they're seeing that all of their friends and family members are sitting at home making 2,000 bucks and going, well, why am I coming into work like a sucker? Why don't you put me on layoff and I'll apply for CERB and everybody's happy? I would strongly discourage that. In my view, this is akin to an insurance policy. And so where work exists for your employees, you ought not be laying them off so that they can access CERB. If they can and should be working, then they should be at work. If they want, for a variety of reasons, to stay at home, even though there's work, you can always consider a leave of absence, but I wouldn't lay them off if you have work for them. And so the next benefit then is the student relief, and I see that I'm getting really close to my timeline. So the provincial government, it will subsidize up to $7 an hour for a max of $5,000 per employee, and the feds have announced a program very similar to CERB, but that will pay students $12.50 a month if they apply for it. So just to summarize the benefits, then they are ways to get money out to employees as quickly as possible, with the intent being to get money into people's hands and to businesses' hands in hopes that they can navigate the current downturn. I would encourage everyone to look into these benefits if it sounds like you may qualify. And so before I conclude and answer any questions you guys might still have, just a reminder that these are all very general in terms of review. And so I'm just trying to highlight these problems or issues for everyone so that if you do come across them, you go, hey, you know what, Scott was talking about this. Why don't I give my counsel a call? Why don't I give Scott a call? Whoever you choose to call, we are happy to help you work through these issues. And finally, just wishing everyone best of luck. I think everyone's hurting, everyone's struggling, and we are in this together. And I have a lot of faith that we'll all pull through and things will eventually go back to normal. And if you guys have any questions, I'm happy to take them.
We have about 7 questions waiting right now. So I just want to say, in respect of everyone's time, if you want to pop off now, that's okay. But some of these questions are quite relevant to everybody. So I'm just going to go right into it. So first one is, if an employee has worked for 10 years in an organization under a yearly renewable written employment contract, gets laid off because the contract has ended, there are no funds available to continue to pay salary. Will that be a constructive dismissal, or is the employer entitled to give certain notices or layoff pay?
So they're just not being called, if I understand the question correctly, and they're just not being recalled back to work, and so that layoff may end up being permanent. I think that's just a termination in the normal course, if I'm understanding the question, which would mean that there is an obligation to provide notice when that layoff becomes permanent.
Right, yeah. The next question is, sorry, there's quite a few here. Is the entitlement to unpaid health emergency leave due to COVID-19 also dated on or after March 1st?
It only came into effect April 15th. And so I don't think it was retroactive, but if you give me a couple of seconds, I can look it up. But I've been approaching it on the basis that it was only when it came into effect. Yeah, it doesn't have a retroactivity. So it's in force now, but it's not retroactive to March 1st. So it was enacted March or April 15th, I think. So that's when it would have started to apply. Although, I mean, the reality is someone may become entitled to this when previously they weren't, or you may have granted someone a leave of absence just out of the goodness of your own heart. And then once this came into effect, all of a sudden you've got a name for it, or they're entitled to it, when otherwise they may have been on a different leave.
Okay, and the next question actually goes back to one of the earlier questions. If the merged two positions, if you do merge two positions, how do you deal with the employee not offered the new position?
This is a very specific question, and I don't want to go too in detail on it because this is giving some pretty specific advice, and I don't think I know all of the circumstances. But very generally, that employee would just remain on layoff. But there's all kinds of scenarios here, and why you're recalling one over the other, and what basis is it, and are you favoring one employee? Is, you know, are there human rights concerns? There's a number of issues that can come from it. But if you're recalling, just very generally, if you recall one employee and not the other one just stays on layoff.
And the next question I have here are these changes temporary for the duration of state of emergency?
That's my understanding, at least certainly the ones under the regs, because it specifically says that's what they're in application for. I know the intention behind the public health emergency leave was for it just to be related to COVID-19. It says that in the actual language itself. So presumably it will get removed whenever the public or the state of emergency is lifted.
Okay, great. I'm just going to keep coming at you, Scott. How does the COVID-19 pandemic impact voluntary layoffs? If an employer were to provide an option for the employee or employees to get laid off voluntarily, would that employee then gain access to current wage subsidies like the CERB, or would they be ineligible due to the fact that they volunteered for the layoff?
I don't think it should make them ineligible, although that's not my call, that's the government. I think if the reality is there's a lack of work and you're going to be laying off certain amounts of people, and rather than just unilaterally choosing yourself, you offer it out to employees is anyone willing to do this? I don't see why that would change anything in terms of entitlement to serve, just because someone is volunteering for it, as long as there's a legitimate lack of work and people were supposed to be laid off.
Great. The next question is, we are a nonprofit. New Year is April 1st. We have not yet gotten our funding from the province, and we may not get it with the cutbacks to redirect to health. Would it be double dipping to ask the federal government to give 75% subsidy?
I don't think so. I think for nonprofits in particular, the reality is you don't earn money in the normal course. And so your income from year to year, month to month is based on funding. And if you're going through the process and you're looking at our funding in March versus March in 2019 has been reduced by 30%. I mean, it sounds to me like it would qualify. I mean, it applies specifically to nonprofits. And so I guess you have to tailor it to your rubric of how do we measure our income year over year or month over month. But it seems to me that that should apply.
Okay, next one. If you're using the CEWS and are not topping up the employee's wage by the remaining 25%, could this be considered constructive dismissal?
I think it's a risk. I think if someone came to me outside the pandemic and said that we are going to be reducing someone's wages by 25%, I'd say, well, you have a very good chance that someone's going to say they've been constructively dismissed. I think in the current circumstances, it's perhaps unlikely that somebody says that, because I like to think that everybody is going to try playing nicely in the sandbox together. I realize that for that program in particular, if the option for the employer is just to not have them work at all versus working at 75%, they're probably going to take the 75%. So in a roundabout way, I'm saying, yes, the risk of constructive dismissal is there. Will an employee actually say that at the end of the day? I think the odds are no, but they could.
Okay, and then we just have 2 more questions. I'm going to cut off the questions right now out of respect of time. If their ROE says reason is leave of absence, does that not count as a layoff?
Under the ROE boxes, if you go through the codes online, it gives you a bunch of different options, and layoff has a different code than a leave of absence. So it is different. Now, that doesn't mean that you can't retroactively change it. You can always reissue an ROE. So if the real reason was layoff rather than leave of absence, I think you can probably go back and change it.
Okay. And then if an employee lives with their aging grandparent, is that a reason not to come back to work? If an employee is stressed out due to COVID, can they continue to draw from CERB and not come back to work until the CERB ends? Do they need a note from the doctor or not? Do we take employees' word for it?
This is where it gets very dicey and where you need to be flexible. So just using the grandparents or aged parents as an example, I think the first thing I'd want to do is say, well, why are you caring for them now, but you weren't caring for them before? Like, is there a real reason why you're caring for them now, or is this an excuse to refuse recall to work? There might very well be a real reason why they need to take care of them now when they didn't before the pandemic, but I would be suspicious of someone saying that they have to take care of them now when there is no reason they had to before. But that's all to say there might be a real reason for it. It might be that someone else who usually cared for them can't, because they're in a high-risk environment where they're exposed to COVID all the time. So it makes sense for someone else to take over those care duties. So again, very circumstance dependent. With the stressed employee, this is where you're caught between in a catch-22, because we no longer can ask for medical notes in certain circumstances owing to the amendment to the code. So that's a very specific one that again would depend on the circumstances, but you might not be able to ask for a medical note. You might have to take them at their word, but I would want to explore those circumstances in far more detail before I made a decision on that.
All right, and that's it for questions. I did put into the chat there that if you do have any further questions, please send them to my email address. It's the members@brandonchamber.ca, the same one that sent out this link. Or you can send it off to Scott as well. I put his email in there. But I just want to thank everyone for attending, and a big, huge thank you to Scott. I'm getting lots of great messages here about how insightful this presentation was. So thank you for your time and the work you put into this, and stay well, everyone. And come to more virtual events. I like seeing all you guys. All right, we'll head out. All right, bye now.